Hello, everybody. Welcome to I think it's the fifth or
Fifth,
sixth, the
the
fifth
fifth. Mhm.
Modest Means Helpline small webinar for small businesses. And today's topic is top 7 legal mistakes businesses make. We're very, very pleased again to have Larry Donahue with us. Larry is with the firm's Law for Small Business. I imagine he'll tell you a little bit about that when he starts talking. We are recording this webinar. It will be up on the State Bar's website under the Modest Means Helpline tab, and you can access that. It'll be up and probably by tomorrow, as are all the other webinars we have. And this webinar is presented by the Modest Means Helpline, which is a legal helpline housed at the New Mexico State Bar Foundation. It's one of 2 legal helplines, and it is for civil legal problems, meaning not criminal issues. It's a telephone helpline and also a attorney referral service for people who are at or below 500% of federal poverty guidelines. We do an intake process, and we can assist folks with legal issues. Legal advice on domestic relations cases, meaning things like divorce, custody, kinship, guardianship, domestic violence. We also talk to a lot of folks about landlord-tenant issues and small business issues and consumer issues and probate and a few other odds and ends here and there. Our attorneys give legal advice over the phone, and if it's the type of case that is appropriate and the person is of very low income, then we can do a pro bono referral to a member of the private bar.
Mhm.
And this shows our hours and how to get a hold of us. And so I think with that, I also want to mention that we have with us Mia Lorenz. She's our staff attorney at Modest Means Helpline who handles the small business callers. So if you are ever in need of legal advice and you call in, you might probably are going to be speaking with Mia. So with that, I'll let you take it away, Larry.
Great, thank you so much. And I really appreciate the New Mexico State Bar Foundation for supporting this. And I'm going to talk about the top 7 legal mistakes I see. And I'm going to start with 7 and do like a David Letterman. If I'm showing my age there, I apologize. We used to do this top 10 thing that I always thought was great, and get to the number 1 issue, whatever he wanted to talk about. For me, that would take too long. So I don't have a top 10 list, but a top 7 list. I think it'll work out. And who the heck am I? I'm a business lawyer. I've been a lawyer for 30 years. I'm licensed in the state of Illinois as well as the state of New Mexico. And I am the founding and managing member of 2 law firms, Business Law Southwest and Law for Small Business. And interestingly enough, I actually got a D-board complaint that I'm having to respond to. Just lovely. We lawyers love D-board complaints. And so I'm doing some research. They're basically complaining because my team wasn't responsive enough. They left us a negative review on the internet, and I responded to the review, and they felt threatened by my response. And the reason I'm explaining this is that Law for Small Business is a business, just like anybody else, and we go through the same issues that our clients do. And so it really gives me 2 interesting perspectives. One is, just trying to run a successful small business in the state of New Mexico with all the hiring and other issues that every other business has. And then, of course, I see the problems and issues that our clients have. And at any rate, in my D-board complaint, I wanted to do a little bit of background about Law for Small Business and, who we are and what we do. And here's a little interesting factoid. We've been selling internet services, let me rephrase that, legal services on the internet for probably, since 2012 or so. My records go back as far as 2015 because of the system we use. And we have about 75,000 orders in our system.
Wow.
Between 2015 and today. That just can give you a sense of how insane that is. And so when you have that many, and not every transaction represents a client. We'll have one client, maybe they'll do 5 orders with us in the span of, a year or something. But it's still a significant number. And because of that, you get a sample size of even 1,000 people, let alone, 50 or 80,000, whatever this number represents. And some of them are going to be just nuts and crazy or mean or spiteful or whatever the situation is. And at least I think I have a lot of training on how to deal with that. And unfortunately, a lot of businesses don't. And so what I'm going to talk about here is like these issues that aren't generally well known by laymen or non-lawyers. And, I think it's important that all business owners know these issues and avoid them. Otherwise, what you end up doing is feeding the lawyer. And I love that, by the way. Your money is green. I'm happy to take it. But if you would like to avoid feeding the lawyer and instead feed yourself or your employees, it's important to understand these things. And so,
Hey, Larry, one thing real quick. I don't think I mentioned, if people have questions as that we're going along, put the questions in the chat and we will bring those to Larry's attention. Sorry to interrupt.
Oh, not at all. And actually, I have that up. So I'll see that interactively, and please ask away. That helps me feel like you're actually paying attention and I'm not boring you too much. I will give you some examples too to hopefully make this pretty entertaining and interesting. But every single one of these that I'm bringing up, I encounter them weekly, monthly. And so I hope that you'll find some entertainment out of this, as well as hopefully improve your practices with your business. But number 7 is ignoring the professionals. And my recommendation is that you should be on a first name basis with at least 3 types of individuals. First, a CPA, then a banker, and an attorney. And those are very different individuals. And I know you know that, but there's practical issues where you're like, well, wait a minute, when do I talk to a lawyer versus an attorney or a banker? Why do I need to talk to a banker? I don't need money. Well, let's talk about that. But the first issue is the general issue is, are you dealing with tax issues? That's a CPA, not a bookkeeper. It's a CPA. And I'll explain what I mean by that in a minute. Cash flow issues is going to be a banker. And there's a lot of issues around what cash flow means and why having a good relationship with a banker makes a big difference. And then here's the big one. Any third-party issues, that's the lawyer. So if you have a dispute with an employee or a vendor or a contractor or the government or a police officer, that's a lawyer. Your CPA is not going to be able to be very helpful in those situations. And what I recommend is you take advantage of these people. You need to look for people who understand your business and your industry, who aren't going to sugarcoat their responses to you, but they're still going to be respectful to you because you deserve respect. You're paying for their services after all. And then they need to be responsive to you, and they're not too busy to really listen to you. And so when you hear me saying, well, we've had 75,000 clients since 2015, yeah, factor that in. Is Larry the lawyer maybe too busy for you, and you want somebody that's going to pay a little bit more attention to you? Now, that doesn't mean I don't pay attention to my clients, but I hope you understand that I might be considered a busier lawyer than other really good attorneys out there, maybe younger lawyers that don't have as many clients as we do. And that might really be helpful to you because you need somebody to understand who you are and who your business is. And you want them not just to be offering advice to you, but ideally being strategic for your business, introducing you to others who can maybe add more value to your business, maybe bring in business. So my connections are significant, and I have the ability to introduce clients to other professionals, people with money, maybe other employers, partners. I mean, and you should take advantage of that if you're hiring me, and you should expect me to do that. And if I don't do that, I'm not doing a good service to you, in my opinion. So For lawyers, and I'm going to talk about lawyers first, but I'm going to talk about the other categories first. You need to be aware of the internet and non-lawyers on the internet. My God, and you know this, I'm sure you do. I see the younger generation looking at TikTok, and they're getting like 30-second videos on advice. And I don't know, these people are morons. The advice they're giving is ludicrous. And that's not to say there aren't good people on TikTok. What's difficult is determining who are the people that really know what the heck's going on and who isn't. Resumes and bios just aren't available on TikTok unless they give that to you in the video. And a lot of them don't. So the other big issue you got to be aware of on the internet is this false sense of accomplishment. And it's kind of a ticking time bomb. And let me mention what I mean by that. There's this service you may have heard called Trustpilot. And a lot of internet service companies will say, Trustpilot reviews, it's 5 stars. And we've served, 50,000 people. Well, the problem with Trustpilot is when you make your order, you are basically saying, whatever it is, let's say it's a trademark. You want to hire a company to do a trademark for you. You type in all the information. At the end of your order, the Trustpilot thing pops up and it says, rate your experience. And, it's an order. How hard and difficult is that? So most people are going to give it a 5-star review. And then these companies are trumpeting that as a 5-star service. But what those ratings are really is the order process. And so you will have this sense of accomplishment, and you're looking at the companies with these high 5-star ratings, but they really don't address the service itself. And so, for example, it's easy for the Secretary of State to file an LLC, for example, but just filing the LLC with a certain name doesn't mean you have the trademark for that name. But you think it was approved. You think it's okay. It will give you a false sense of accomplishment without really doing more and talking to a professional. So these are things to be concerned about, or you got to worry about a little bit. You should talk to an attorney when you are starting out, when you're interacting with any third party, whether it's a landlord or a vendor, partner, customer, investor, employee, contractor, or whomever. If you're in a dispute, and that doesn't mean you have to hire the lawyer to deal with the dispute for you, but it'd be very beneficial to talk to a lawyer, at least so you understand what legal levers you can pull, what options you have available, so that you don't inadvertently get yourself into too much trouble with this dispute that ends up turning into a lawsuit. Another thing to consider is when you get a government notice, especially when they demand information or documentation. A lot of people don't understand that when you get a notice, for instance, from Workforce Solutions saying, we want to know everything you have about this particular ex-employee, we want their payroll records or whatever, and they ask for a lot of information, and guess what? It pisses business owners off. Business owners are like, why do I have to respond to this? It's a bunch of lies anyway. And so then they don't respond. And guess what? You've just put a nail in the coffin on the record. And we lawyers don't have the ability to appeal or set things right if a decision isn't made in your best interest. So talk to a lawyer first before you do anything, no matter how angry or annoying you are. Or not annoying you are, but how annoying the situation is. For CPAs and accountants, I want to highlight that bookkeepers are not accountants, and they're especially not CPAs. And so I've seen time and time again where an honest, hardworking business owner is trying to figure out what they can or cannot exclude from gross receipts tax, for example. It confuses people a lot when they're doing business on the internet. The New Mexico rules do not make things easy or intuitive, unfortunately. And so if, heaven forbid, you talk to a bookkeeper and the first thing out of the bookkeeper's mouth, and I'm not trying to knock the expertise of a bookkeeper, but they do not have the training, number one, and they don't have the accountability that a CPA will. And so usually what you're going to hear out of a bookkeeper's mouth is, well, usually I see people do X. That's like the lemming theory, and you want to avoid that. So you really need to talk to an expert. A CPA specifically is going to be able to give you advice, and you can hold the CPA accountable if that advice isn't correct. I also want to warn you, do not get behind on tax payments, for example. Some tax obligations are not even dischargeable in a bankruptcy, and they can follow you for the rest of your life, even if you change your business. So if you own business A and for whatever reason you have trouble paying gross receipts tax and so on, if it's not handled properly, that can follow you personally. So your business declares bankruptcy and you open up another business later. Guess what? New Mexico Tax and Rev can go after that new business under the theory of successor liability. So you need to be on top of this stuff. Do not rely on the internet at all. And please, if you think you're smart enough to know what you can exclude from gross receipts tax, I would really love you to get a formal memo from a CPA. That can potentially help you in criminal circumstances and potentially limit certain types of penalties or liabilities if the advice is wrong. Talk to a CPA when you're setting up your first chart of accounts. They're going to help you figure out, how to record and keep track and pay gross receipts tax, what are proper expenses for the business. If you're trying to determine what is and is not deductible or exempt, a CPA is going to be great to help you out. And especially if you have somebody telling you that they don't have to pay New Mexico gross receipts tax. I can't tell you how many times people tell me that as a lawyer. And it's like, okay, well, send me an NTTC. And they're like, what's that? And it's like, okay, you got a bigger issue here. And it depends. Not everybody has to send an NTTC, by the way, but it's complicated. And when you hear a lawyer say complicated, that's fraught with a lot of potential problems. Finally, let's talk about bankers. You need to know that tellers that you walk into a bank and talk to, they may not even have a college education. They're at the bottom rung of the bank. And so the tellers, they're very nice and that's great. I'm not trying to knock them, but they're not the ones that you need to have a relationship. What you want to do is have a relationship with the business bankers at the bank. They're going to be behind the teller line. Sometimes they might have offices somewhere in the building. Those are the folks. That's somebody you want to have a relationship with. The other issue is a finance company is not a bank, and it's a lot easier to get a loan from a finance company, but they're going to have huge upfront costs. They're going to have hidden costs. And generally, what I've seen over the past 30 years of my lifetime as a lawyer is when a business starts getting financing from a finance company, it's kind of the beginning of the end of that company. They typically don't. When I say typically, I'd probably say 80% are not able to keep up with the payments. The finance company has leaned the accounts receivable, and they could do all kinds of terrible things with the business. So avoid finance companies. You want to work with banks. They're very difficult to get out of. Also, here's a big surprise. The law doesn't care about you. And I know that sounds horrible, but let me explain. We are used to, like, as college students, renting, and we're used to, like, there being laws to prevent like slumlords from taking advantage of residential leases. There's nothing like that in New Mexico law for commercial leases. And that same kind of thing extends to just about anything. The law assumes that you, the business, have the clout and money and negotiating power of a Walmart. And most small businesses don't, but the law is written that way in most circumstances. So that includes crazy contracts by financing companies. They can do all kinds of horrible things, even if you sign as an individual, but for the business. So think about that for a minute. You lose your typical consumer protections around lending and predatory lending in a commercial setting in certain circumstances. So you need to be very careful and leverage the appropriate people. And a banker doesn't do that. The rates are going to be a lot better. Talk to a banker when you don't need money. That's the best time to get a line of credit. And it's just for a rainy day. And if you don't need it for 2 years, great. But it'll be there if and when you do need it. Also, bankers are great to introduce you to other people, especially hard to reach customers and strategic relationships. Also, I bet you every business leader here has had this problem where you get a suspicious check or a weird client request. How do you navigate that? And just because you have what says in your hand a cashier's check doesn't necessarily mean it's cash. It could be a fraudulent cashier's check. And if you have a banker you can call and talk to, that'd be very, very helpful for you. And then, of course, bankers are going to have much better interest rates and closing fees. They're going to disclose things properly and develop a long-term relationship with you. So you really need a good relationship with a banker. So I know I belabored that a lot because I think it's really important. And I can't tell you how many arguments I get on a weekly basis. Somebody saying, oh, I called so-and-so. I read this on the internet. What you're telling me isn't true. And it's like, well, okay, then go follow that advice and remember my number. If you run into trouble, we'll help you out. So let's go to number 6, poor contracts or no contracts with third parties. And I want people to understand how important contracts are, even for small, crazy little things. And I'll mention that in a minute, but let's talk about contracts briefly. Contracts allow you to maintain accountability and establish responsibility with another party. And it can help either them or you ensure payment. And you can control, like, when you can terminate a contract or not, and what conditions might be involved around termination. It allows you as a business to limit or establish warranties and indemnities and liabilities to protect yourself. I've seen instances where it was a concrete surfacer. They would like go and make a concrete floor look beautiful. And they did not have they had a warranty clause, but it wasn't a limitation of warranty. It basically said, if you're not happy with your floor, we'll go and replace it. It was the dumbest possible thing they could put in the contract, right? Because they ended up doing a really nice floor for a really expensive home in the Santa Fe area, which did not have a great pad on it. And so the pad was creating problems and being uneven and cracks. And that really was the fault of whomever did the concrete pad, and of course the home builder. But the home buyer who hired my client was blaming my client for the cement surfacing on the cracks, and went in there 7 or 8 times redoing the floor before they finally called me. And it's an expensive argument to make, and we lawyers love expensive arguments. Do you know why? Because we get paid for our time. So the more expensive the argument, the crazier things are, you're doing me and my expensive car justice. So don't do that. Don't feed the lawyer. Think about the contracts that have these terms in it. Also, you want to control dispute resolution. When there's a dispute, what's the process? How does it work? How can you get out of a dispute without having to go into an expensive lawsuit? And let me tell you quickly about lawsuits. If you're in a lawsuit, you need to hire a lawyer. And lawyers are going to have varying rates, anywhere from around $200 an hour to $500 or $600 an hour. And they're going to require retainers. Depending on the lawyer, we require a $10,000 retainer. So we're not going to represent you unless you can at least pay that $10,000. And guess what? That's not a deposit. That is your money. It goes in a trust account and we bill against it. But you need to keep it at that level as we go forward. And we've had trials where just within the span of a week, we're billing over $100,000 to the client because of a litigation matter. This just happened, actually, just last month. Our client was on the hook for an $800,000 demand. They were being sued for $800,000 plus attorney's fees. The judge hated our client for some reason and was constantly deciding against him. So we forced a jury trial. We won at the jury trial. But guess what? A jury trial is not favored because it's a lot of work. We have to prepare more evidence and documents. We have to be really clear and present things carefully to the jury. So it takes a lot more expense to do that versus a judge. So bench trials are generally preferred in business disputes when we can get it, unless the judge hates our client. Now, judges are very good in New Mexico, and it's very rare we have some sort of weird thing where we think there might be some bias against our client. In this case, there was. So at any rate, we moved to a jury trial. We won, but we ended up spending $100,000 within the span of about a week or two winning this trial. So our client was ecstatic that they didn't have $800,000 judgment plus attorney's fees, but was not very happy getting a $100,000 bill from us. So what's my point with this? Don't get into the lawsuit. Avoid the lawsuit, and that's going to help with a good contract. There's a few other things here. Establish the length and dispute procedures, and important contracts you need to know about from a business perspective. And here's what I mean by that. A lot of businesses don't understand that there's this thing called the Unfair Trade Practices Act. Remember I said the law doesn't care about you? Not only that, the law is actually against you in some cases, and this is an example of one of those. The Unfair Trade Practices Act isn't allowed for businesses to go after consumers because consumers don't pay their bill. It's for consumers to say, hey, this business wronged me in some way. All it takes is some sort of proof of a malfeasance, a wrongdoing, such as a misstatement, a misstatement of fact, a misunderstanding could potentially be used for an Unfair Trade Practices Act claim. An Unfair Trade Practices Act allows up to 3 times the damages of the complaining party plus their attorney's fees. So it's really hard to defend against, except if you have a contract that says, if we have a legal dispute and I win, you got to pay my legal fees. Now that raises the bar and raises the risk associated with a fraudulent or a weak lawsuit against your business. So you'd want an attorney's fees claim to try and fight something like that. But there's other things. There's like a merger clause, parole evidence rule. This affects oral promises from overriding contract language. And so I can't tell you how many times a business leader will come to me and say, well, this is what we discussed. And it's like, I don't care. I don't care what you discussed. I need to look at the contract. That's really what's going to matter. Now, when I say that, there's always exception to things. There's complexity. Remember what I said about complexity in lawyers, expensive. So, and then there's a drafter's rule in New Mexico, by the way. Ambiguities in a contract are interpreted against the drafter. So if you downloaded a business document off of the internet for your business and you haven't really gone through it carefully, what I mean by that is you've hired a business lawyer to go through it for you. It's very likely there's going to be ambiguities in that contract. And then heaven forbid, if you're in a fight, those ambiguities are going to not just be ignored, they're going to be interpreted against you in your business. So don't do it. And then I mentioned attorney's fees clause already. It really does. This isn't Larry the lawyer being self-serving. What it does is it prevents, or it doesn't prevent, it helps shift the risk burden to the other side. So if they're going to go after you for some reason, they run the risk of paying your legal fees. That really acts as a disincentive for contingency claims by other lawyers, as well as other people who just want to go after you. So it really helps to have that kind of language in place. So I recommend adopting high quality standard documents for your business, especially for your clients and customers. Do you generate proposals? If so, take the legal mumbo jumbo out of the proposal, because people get confused and frustrated with the legal jargon. So you want to have a nice, sexy, easy to explain proposal, work order, cost estimate, whatever you call it, to get the customer to yes. And you want them to sign it, and you want to incorporate another document, a terms of service, a master services agreement, intake, whatever you call it, but you separate them. So your proposal is to get to yes. Once they've said yes, now you can bring up the contract that they have to sign to move forward with your services. But it's now an administrative issue versus a business issue on whether they want to do business with you. So I mentioned that. The other thing is intake forms as appropriate, attractive first page, make things sexy, professional. That's what people want to do business with. Then you can put the terms of service on the backside. or as a separate document. Typically, people don't read these. I think they should, but they're certainly going to read them if they have to read them before they decide to do business with you. But this is my opinion, and I'm sure good lawyers are going to vary on this. I could see, Mia over there smiling about this. I'm sure she has a great opinion on it. Also, adopt standard employment in contractor agreements. I think they're an absolute must. Note that an ideal document isn't going to change from employee to employee or customer to customer. You want to have a template of some sort and then extract out as an addendum or attachment or something, things that can change, whether it's scope, time frame, price, starting times, deposits, things of that nature. Obfuscate that so you have your general terms of service that don't change. And that'll help you eliminate and reduce legal costs going forward, adjusting contract language and stuff like that. Because people tend to not look at that much. They care about the other stuff, the price, when you're going to start, how they terminate, stuff like that. You can separate that language. And let's go to number 5. Partnership disputes or poor formation documents. And now here is a newsflash, because this represents probably 40% of my firm's revenue is partnership disputes. And it's worse than a divorce. And it kind of makes sense if you think about it, right? Because divorces are bad, right? But with a business, you're talking about potentially your most valuable asset and your entire life's savings and work. And now you got this partner that's jeopardizing everything. And so these disputes can get tremendously ugly. And so now I'm just going to share with you a sampling of the fun stuff I've had to deal with just in the past 3 years. This one can happen, dies or becomes incapacitated. But what happens if your partner's a narcissist? Or they steal from the company, or they insist on hiring unacceptable friends or family, or they become disengaged or disinterested, or they don't pull their own weight or contribute funds that the company needs. What do you do when something like that happens? What happens if they lock the doors or remove you from the bank account, or they try to kick you out of the company without any cause or reason or legal justification? What happens if they start a competing company, or they continue to work for you, but they redirect business or leads to that other company? Or if it's a professional, a contractor, attorney, doctor, they lose their license, or they're arrested, or they otherwise, become a liability to the business, or attack or threaten you, or they're an investor, but now they want their money back. Now, by the way, I didn't even bring up drug use here, did I? But that I see that, especially, and I'm all for cannabis, by the way. I'm not a user myself. That's okay. I think it's great. Other people can, and I'm very proud with New Mexico's position. However, I have seen a rise of people that think they can partake and then show up to work. It's like the equivalent, in my opinion, of drinking and then showing up to work. It's not appropriate. There's a time and a place for that. And it's not during your 10-minute smoke break or 15-minute smoke break or whatever. That's just unacceptable, in my opinion. And if you got a partner doing that, then one, their performance, in my opinion, is compromised. And two, what kind of example are they setting for the other employees and or the customers and clients that might show up? So there are a lot of reasons why a partnership can fail, or that the partner can create problems for the business. And guess what? Remember what I said about the state of New Mexico and its statutes around business. It doesn't care. And when I say that, it sort of cares. It has some laws, but they're very general, very basic, and they're not necessarily going to control bad behavior. They might affect illegal behavior, such as violence, but even violence, that's a criminal offense. That doesn't kick anybody out of the company. That just, gets the criminal system involved with somebody. So it's a partnership, a document that you want in order to avoid these things. So for an LLC, that's an operating agreement, not one you just downloaded off the internet or some non-lawyer gave you. You need to review it and make sure it actually covers your business and deals with these edge cases that I raised earlier. For a corporation, there's no such thing as an operating agreement. It's bylaws. There are some optional documents too for either any of these. It might be a buy-sell agreement, and that can force a buyout under certain circumstances, a restriction agreement. And now, an operating agreement can serve as both of those if it's a well-written operating agreement. If it's a corporation you have, then the bylaws are generally very high level, how to conduct meetings, stuff like that. And you're going to want other optional documents to create more control on certain circumstances, the edge cases. Finally, there could be a purchase agreement. You'll see this a lot if you want to give employees some level of ownership. When the employee is no longer employee, what happens? Ideally, the business should have the ability to claw back or buy back that employee ownership if the employee is going to terminate their employment, or if they get terminated for cause. I mean, the possibilities here are endless, but I want you to think about them and make sure you have the right documents that address what it is you want for your business. Remember what I said, very little under the law to protect you. The partnership documents are what is going to do it. And there's very little you can do in the face of bad behavior without the right document. It can be very difficult and expensive to remove a partner or enforce your rights. Cops aren't going to get involved in civil matters. They just aren't. That's not what they do. They don't do that well. And when I do see them get involved, they almost always make the wrong decision because they don't know what the issues are. They're just trying to prevent violence. They're trying to, they're enforcers of the peace. That's their goal, not to make sure that the right business person gets their rights properly enforced. So I mentioned the law on these things is very high level, doesn't address these things. But the big point I want to make is never just walk away. There's more work you have to do when you try and get out of a partnership. So that's going to bring us to number 4. Signing contracts without reading or negotiation, right? Do I need to say more on this, right? Shouldn't you know as a business owner, don't sign a dang document if you don't read it and maybe negotiate it? This happens so often though. And really, God bless my clients that run into this. They're just trusting individuals. They had a great relationship with somebody. It could be their best friend or a family member. And so why would you read the contract? You trust that individual. The answer is because they may not have read the document either. They may have downloaded off the internet, and guess what? Your beef isn't with that individual now, 3 years later. It's with their estate or their ex-wife or a child you didn't know about that's the beneficiary of their estate. And so that's the issue, is you don't want to look at what kind of relationship you have with the person standing in front of you. The contract is for when the relationship breaks down or that individual's no longer there. How do you protect yourself? How do you protect your business? And so there's some important considerations here. I'm not trying to teach you how to be a lawyer. I'm just trying to give you some real quick tips and guidance so you can quickly look over a contract. And there's some red flags I want you to be aware of. And one of them is the proper legal names of the parties. Now, if you have an LLC or corporation, I don't want to see your name on the contract. It's the LLC or the corporation, not you. And so if your name is on the contract, that's not a proper legal name. And vice versa, who is the party you're doing business with? Is it Acme? Who the hell is Acme? I want to know it's Acme LLC, a limited liability company in New Mexico. Now that helps me a lot of where this company is located so I can hold people accountable. I can properly serve them. I know where to file a lawsuit. Help the lawyer. When you help the lawyer, you make things simpler. Remember, simple, less expensive. Complicated, more expensive. There's other issues. Are all the promises mentioned in detail? Now, what I don't want you to do is get yourself into a contract that says your obligation is to pay. Their obligation is to market for you. And I'm just using market as an example. What the hell does market mean? It could mean one Google AdWord a month. It could mean a $100,000 advertising campaign on the local media. If you don't define what marketing is, how do you hold the other side accountable to do the job? Now, they can hold you accountable because it's really easy. You're supposed to pay $10,000 a month. And if you don't pay $10,000 a month, you're in breach. You have liquidated damages and other issues and problems. But how do you hold them accountable? I want you to think about that. What do you require and need for them to perform? And those need to be mentioned in detail. And remember what I said earlier, oral is meaningless. The words out of their mouth, just put up your hand and say, shut up. I don't want to hear what comes out of your mouth. It has to be on the document. Just don't buy into that. Don't listen to the oral stuff. It's got to be in the contract. And think about what can go wrong. I call them edge cases. What can go wrong with the contract or the deal, and make sure you have the edge cases in the contract. Are the dollar amounts and dates correct? I can't tell you how many times I see something simple like that wrong. Or I've seen where there's like a liquidated damages clause, a $200,000 liquidated damages clause, and it's for the other party. And my client read $200,000 liquidated damages. What liquidated damages is, by the way, is if there's a breach, the other party doesn't have to prove damages. It just says $200,000. We're not going to argue about damages of $200,000. But the liquidated damages clause only apply to the other party, not my client. You want to make sure it's applied properly. Is it making too many promises? And what happens if you can't fulfill? Are you in trouble? Do you have a way of backing out if you can? COVID was a great example. Well, what do you do if you can't even show up? You can't even open up your doors. Do you have some ability to back out in circumstances that may be beyond your control? I brought up fulfilling promises. And are you in control of your obligations, by the way, or are you relying on other third parties? And if you're relying on other third parties, you need an escape clause of some sort if, it doesn't work. Finally, fair and balanced. Now, leases, if you're a landlord or you're a tenant, I've never seen a fair and balanced lease agreement. Landlords have tremendous power over their tenants. But I got a news flash for you. There's a glut of commercial real estate in New Mexico. And you have the ability to negotiate and you have the ability to walk away if the landlord's not willing to give you a fair and balanced lease. You need to learn to say, I'm going to look elsewhere. Don't fall in love with a particular site. And we're going to talk about that in a few more minutes. Are there mission critical issues? Are there long-term implications? And then is there an evergreen clause or a deadline to invoke an option? In New Mexico, if you're 1 day off on a notice, you're screwed. So you need to make sure you look at the contract, and if there's an evergreen clause, which means a contract automatically renews. If there's an evergreen clause, get rid of it. If it affects you, unless it's beneficial to you, then you want it. But if it affects you, you want to make sure that you have a good notice provision. What that means is you need to be able to say, I'm going to stop. I don't want this contract to automatically renew. A lot of contracts will have a notice saying you have to tell us within 30 days, 60 days, 90 days of the renewal in order for us to terminate. Otherwise, it's going to renew automatically and you're going to owe us more money. You want to put that in your calendar and make sure you keep track of that. Because remember, if you're off by a day, it doesn't matter. If you send a notice a day late, it doesn't matter in New Mexico. And then I mentioned the pandemic earlier, but that's an edge case to think about because it's a good one. What happens if there's something nutty that is totally outside your control, or the government says you can't open your doors, or employees can't, stand within 6, 10, 12 feet of each other, yet you got some sort of complicated process that requires people to stand next to each other. What do you do in those circumstances? If you have the ability to back out of a contract in such circumstances, make sure your contracts have that. Alternatively, you hire a lawyer to review the contract. But honestly, I think you can't be hiring a lawyer for every possible contract. You need to have some of these skills in place and then understand when you do have an important contract and you get an attorney involved. So a couple of things that should really upset you. I want you to get mad if anybody does these things. They hand you a contract and then instead of allowing you to read the damn thing, they're explaining it to you. You need to politely put the pen down, look at them, I'll get angry about it and be like, look, I'm going to need to read the whole thing. I don't know when you want me to review it, but the words out of your mouth are meaningless as it relates to I'm a jerk sometimes. I'm sorry, but it's because I get mad about this. And then especially somebody says, don't worry, if it's not in the contract, we'll do it. We always do it. No. It's got to be in the contract. Get mad about it. If they pressure you to sign right away, instead of taking time to review it, think about it, or hiring an attorney, don't do it. Don't succumb to the pressure. Get mad. And if anybody represents both parties in a transaction, you should look at them and be wary of them. And I'm talking to you brokers because brokers do that a lot. And I don't think you cannot adequately represent both clients. For us lawyers, we are prohibited from doing that. It's called a conflict of interest. We cannot do that. If somebody's representing both parties, exactly how can they be fair to both parties here? Is a lien appropriate or not? Is a bigger deposit appropriate or not? Who knows? But somebody that is on both sides of a transaction, they're not going to be able to give you the best possible advice, in my opinion. So get angry about that. If there's a contract that awards attorney's fees to the other party, but not you, get angry about that. If it has lots of penalties for you, but none for them, like I've seen leases where they have like 2 or 3 pages of penalties associated with a tenant, and then for tenant default, but then you look at landlord default and there's literally like a half a paragraph. I mean, that's ridiculous. I get mad about it. I get mad. You should too, in my opinion. And then when I mentioned this earlier, if they're really specific on payment because they want to get paid, but they're not specific on what they're going to do for you, get angry about that. So we have about 12 more minutes. I'm going to go a little faster here because I think some of this stuff is obvious, but it still needs to be said and it's still important. And it's the top 3 because I see this so often. The number 3 here is doing things incorrectly or illegally. And remember what I told you about the state of New Mexico. They're not looking out for you. So state agencies don't verify information. And I mentioned this earlier with the Secretary of State. They don't look at your name to see if it's going to violate a trademark. All they're trying to do is prevent duplicate names with that could confuse each other in the Secretary of State's database. That's it. If you said Mickey Mouse owns the company, they're probably going to put Mickey Mouse in the database because they don't validate or verify any of that. So you can't look at that in terms of determining who are the proper owners either, by the way. Just because somebody's listed in the name of that company doesn't necessarily mean it's accurate or is proper information. So do not rely on that. And then the other thing I see a lot of is I'll see out-of-state businesses come into New Mexico, as well as a New Mexico company going out thinking you understand the law in that other state. So I'll give you one example, just between Texas and New Mexico. New Mexico, you have to register and have an actual contractor's license to do business in the state of New Mexico for doing general contracting. That doesn't mean a city business license. And that can confuse people because in Florida, and I think it's true in Texas as well, if you get a local business license, you can do certain contracting work without more, but not in New Mexico, you can't. So you can get yourself into trouble. So you can get this false sense of accomplishment that I mentioned earlier, just because you filed your company and the Secretary of State approved it. That doesn't mean you got a trademark lawsuit coming down the pipe from somebody in New York or Miami or Chicago or somewhere. So beware the lemming theory. And that is when somebody else tells you, well, this is how we all do it, or this is how, I see everybody else doing it, doesn't mean it's the right way to do it. And so you need to be careful about that. And in New Mexico, as well as most jurisdictions, we have this concept called negligence per se. What that means is if you do something and somebody gets hurt or there's damages, and it results from you doing something illegally or incorrectly. For example, a sign company hired somebody to dig holes for putting signs in, right? Seems innocuous, but guess what? Depending on what jurisdiction you're in, at the city or county level, would require you possibly to call before you dig. And it doesn't matter if you're digging 1 feet or 20 feet, you're supposed to call and possibly get a permit. And if you don't do that, and heaven forbid you break a gas line and somebody gets hurt or killed, or you break a fiber optic cable or something like that, you are on the hook. And it's negligence per se, which means it's automatically negligent. You don't have any defenses. Cough up and pay up, basically what that means. So poor decisions, bad behavior will eventually catch up to you. And you need to be aware of this. Under the laws of agency, if you have an employee or contractor do something on behalf of you or your business, you are responsible for their illegal or negligent acts. Even if you tell them not to do it and they do it anyway, you or the business are still in trouble. So what does that tell you? Don't hire idiots. Don't hire people that you know are going to smoke cannabis on the way to a job. And I'm not trying to knock cannabis. It's just prudent behavior and making sure you hire prudent people to represent you in your business. So there's a few things I want you to be aware of that can create actual jail time. And one of them is providing certain services that require a license. An easy answer here is like a lawyer or doctor, you think, for instance, everybody knows that. Well, what about like alternative medical therapies? Is that appropriate or not? Can you do that with or without a license? I am not the lawyer to answer that question, but don't make assumptions. You need to do the proper research and make sure that you have a very clear boundary between what it is you do that does not require a license versus what may require a license or serious jail time, especially if somebody gets hurt. Illegal, unpermitted acts, of course, that should make sense to you. But here's another one: securities without a proper registration, improper franchises. I have people all the time saying, oh, I don't have a franchise. I'm like, well, what are you doing? Well, I'm selling my business idea to other states, and then they pay me a percentage of their revenue. I'm like, that's a franchise. Well, no. We don't call it a franchise. And it's like, I don't care what you call it. The law doesn't care what you call it. It's what is being done. And it's interpreted by a state-by-state basis. And the federal rules have their own things around all of this. So don't be doing complicated business deals without talking to a professional and make sure you don't get yourself into trouble, because there is potential jail time, especially California. They are very difficult as it relates to unique business opportunities and things like that. So let's talk on number 2, improper classification of contractors. I've been talking about this forever, and it's still a problem. It's still a problem because everybody thinks it's what we agree to, but it's not. It's what is actually being done. Does the payer, the employer, have the right to control or direct the results of the work? And if not, there's some rules around all of this. So here are the common rules. One is behavioral. Does the company control or have the right to control what the worker does and how the worker does his or her job? Financial. Are the business aspects controlled by the payer? For example, are you collecting the money from somebody and then paying the individual? Or is the individual handling that themselves as a separate business? And what kind of relationship is there? Is there a contract? Is there employee benefits? What do other similar positions typically do for the industry? And here's another news flash about New Mexico. New Mexico's rules are even more strict than the IRS. The general rule for New Mexico is if the individual is doing something in furtherance of that business, they should be classified as an employee, even if you don't want that. Even if, remember the lemming theory, everybody else does it, I don't care. So I'll give you an example, Larry the lawyer. If I hire another law firm to help me on a matter, New Mexico law says they need to be classified as an employee with this firm. It's ridiculous, but that's what New Mexico Workforce Solutions enforces. If I hire a painter to paint my office, well, I'm a lawyer, I don't paint professionally for others. That can be viewed as a contractor. They're going to have their own tools. We're going to dictate a schedule together and they're going to handle it. That's a clear contractor. But if I'm hiring employees helping with setting up LLCs, trademarks, or other legal services, they should be classified as an employee. Unless I'm hiring a company, then there's complex rules around all of this. So the problem with this is if you get it wrong, the IRS or Workforce Solutions could potentially go and look at your classification for all your employees. And they can go and impute salaries. They can go and impute hourly wages. They can go and say, well, wait a minute, you're claiming this person just came in the morning and then left at noon, but it looks to us like they were a full-time employee, but you're only paying them, per job. And so you violated the laws around minimum pay, minimum hourly pay. And so now you have, oh, and by the way, you weren't paying proper withholding and filing properly. It affects, your income tax, because you haven't been reporting that correctly. It turns into this huge snowball of a problem. And it's like, I don't know, sharks in the water with blood in the water. The employees start talking to each other, and ex-employees you hadn't even thought about come out of the woodwork, and all of a sudden everybody's got a claim against you. So to do it right, you need to check with a CPA or business lawyer and make sure you've classified this correctly. Get an opinion letter if you can. Also, the IRS has what's called a Form SS-8, which can help identify status, but that's only for the IRS, not for wonderful workforce solutions. Finally, leases to inexperienced business owners. This is the number one problem that I see, and I'll be able to talk about it in the next 3 minutes. But commercial leases, as I mentioned before, the state of New Mexico just isn't looking out for the business leader. I am sorry to say that, but there is no such thing as a slumlord with a commercial lease. What's on that document almost matters entirely. They have an automatic lien on your property by statute if you don't pay, and there's no protection for another tenant chasing away customers. Like if there's a cannabis or noisy or polluty kind of business next door, there's no protection unless it's in the lease. There's no legal requirements for heating or cooling, by the way. Can you believe that? None. So if you have a business up in the East Mountains somewhere, it gets cold. And if you're responsible for the HVAC, you need to factor that into your costs and expenses. And are you going to be buying the landlord a new unit because that one is 30 years old? Do you even know how old your unit is? Are you sure you're responsible for it? So it's critical to avoid certain language in the leases. If you're going to see landlord approval all over the place, what you want to do is say, not unreasonably withheld or delayed. So you can make a business decision and move forward if the landlord is unwilling to do so. Ambiguous money or language around money owed. Now, remember what I said earlier about contracts. Ambiguous language is interpreted against the drafter. What do I mean by that? That's a court of law. So if you have ambiguous language and we're going to fight about it, remember my $10,000 retainer and all the money you're spending in court. So if you want to avoid that, get rid of the ambiguous language to begin with and get it out of the lease. Also, avoid long terms. You do not want to be in a long-term lease if you can avoid it. And over, I had a best friend who was an engineer at Sandia, smart guy. And guess what? He likes hot yoga. So he decided to open up a hot yoga place where, wait for it, an MMA gym. Now, I can't think of an opposite side of MMA metalheads. And don't get me wrong, I know a lot of great MMA folks, but loud music and they're, fighting. And then you got the yoga folks with incense and kumbaya music, wrong culture. And my friend signed a 10-year lease, even though I begged him not to do it. And of course, he was trying to get out of the lease after the first year. So don't let that be yourself. Remember that silly example I gave you. And so remember, landlords can be very damaging to your business. If they're in charge of the roof and it leaks, they're going to try and say they're not responsible for the damage of the contents of underneath. Think about those issues and make sure you can hold the landlord accountable when appropriate. You don't want to deal with excessive penalties, use of force. They should use the legal process to kick you out, not just be able to go in there and send in Guido to kick you out. Or to move you without compensation. The malls love to do that. They want to say they can send you wherever they want to and then adjust the CAM without your right to audit. So don't allow that. And think about COVID-19. We're a little past that now, but you want a force majeure clause. You want issues around non-essential businesses. And this can apply to anything, not just COVID-19, any kind of government emergency. You know, you want to be able to forbear performance if you have to, and without terminating the lease unless certain conditions happen. So there's a lot of things here to think about. The one thing I want you to be aware of is called doctrine of impossibility. There is something like that in New Mexico, but it's a very strict view, and it basically means you were prohibited from performing due to some sort of government action. It's a very high bar, but it does exist. Any rate, that is it. We are at a little 1 minute over. I really appreciate your time and joining this conversation. Thank you.
Thank you, Larry. You're amazing. Your experience and you're really in the trenches. So your perspective is very much appreciated today.
Yes, thanks a lot.
Of course.
And these are the contact information. This webinar will be up on our website real soon. We don't really have time for questions, and I don't think that I see any. So thank you everybody for attending, and we'll have another webinar. We'll make announcements and have it up on our or notice about it up on our website once we get all the details.